Hi, I'm attorney Jeremy Huss. When do the police have to read the Miranda warnings? And what happens if they don't read them? Let's answer these questions over the next few minutes. Everybody knows the phrase, "you have the right to remain silent," also known as the Fifth or pleading the Fifth. Every person in the United States has the Fifth Amendment privilege against self-incrimination. And it is my advice to always rely on your Fifth Amendment right to remain silent and never speak to law enforcement, especially without consulting an attorney first. Unfortunately, many people do speak to law enforcement when under investigation, and this often complicates the defense of their case. The landmark United States Supreme Court case, Miranda versus Arizona, holds that law enforcement must advise any person subject to custodial interrogation of their right to remain silent. So for Miranda warnings to be required, a person must be in custody, which does not necessarily mean in jail, and we will discuss this in just a couple of minutes, and subject to an interrogation or questioning about the case. The Fifth Amendment only applies to statements and confessions, and the Miranda warnings are only necessary if the police are going to ask a suspect questions. What this means is if the police do not advise a person of their right to remain silent, at most, the statements a suspect provides will be suppressed, and the state will be precluded from presenting the person's statements to the jury at trial. The great American misperception is that a case automatically gets dismissed because police did not read a person their Miranda rights. This is not the case. The only remedy to a failure to read the Miranda warnings is that the suspect's statement will be suppressed. However, a suppression of statements could be so detrimental to the state's case that it results in a dismissal of the charges. But many times, police failure to advise a Miranda will only result in a loss of the statement, not a dismissal of charges or the case. As I stated a few minutes ago, police must only read the Miranda warnings to a person in custody and being interrogated. Interrogation is defined as anything designed to elicit an incriminating response, which is generally any question to a suspect about a case. Whether a person is in custody is a separate analysis. In custody does not necessarily mean that the person is in jail. In fact, people have been found to be in custody in their own living rooms, but not in custody at the police department in an interview. The courts define that a person is in custody when a reasonable person in the suspect's position would not feel free to leave. This is determined by factors indicative of the police treating the person as a suspect. For example, was the person in handcuffs, or was the person told they cannot leave? Also, how long was the interrogation? What was the location of the interrogation? Have other suspects been eliminated? And has the investigation focused onto one suspect? These are the specific factors utilized in determining whether a person is in custody for Fifth Amendment and Miranda purposes. It is clear from our last few minutes that police failing to provide the Miranda warnings may or may not have an impact on a person's case. It is important to retain experienced counsel as this issue must be raised in a pretrial motion to suppress, and if successful, would result in a suppression of a suspect's statements. If you are under investigation for any criminal offense or have a criminal case pending, call the attorneys at Huss Law today for a free consultation.